Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a recent Alberta court decision that sits at the intersection of democracy, Indigenous rights, and constitutional law. In recent years, support for Alberta separation has grown among some who feel the province is treated unfairly within Confederation. Under Alberta's Citizens Initiative Act, citizens can propose constitutional referendum questions and, if they collect enough signatures, potentially force a provincial referendum. One such petition asked a simple but provocative question: do you agree that the province of Alberta should cease to be a part of Canada to become an independent state? In January of 2026, Alberta's chief electoral officer approved that petition, allowing organizers to begin collecting signatures. But the Athabasca Chippewan First Nation challenged that decision in court, arguing that any move towards Alberta independence would directly affect Indigenous and treaty rights protected by the Constitution. In a decision released in May, the Alberta Court of King's Bench agreed. The court quashed the approval of the petition, meaning that the signature drive cannot proceed. The judge concluded that the proposal was legally flawed because it failed to account for the constitutional status and rights of Indigenous peoples, which would necessarily be part of any negotiations over Alberta's possible separation. The decision has sparked debate far beyond the question of Alberta independence. Critics say the court intervened too early in a democratic process, while supporters argue that constitutional rights cannot simply be put aside even for a referendum. To help us unpack the legal issues raised by this decision, I'm joined by administrative law expert Professor Mark Mancini. Mark, thank you so much for joining. Today, we're not debating the merits of Alberta separatism, which personally, as a Canadian, I love Alberta. I want it to remain a part of Canada, but we're not debating that. Instead, we're talking about the legal framework that exists in Alberta. And this isn't really a show about separatism. It's about judicial review and constitutional limits, democratic participation, and the duty to consult. So let's start with the framework that exists in Alberta. Can you explain the background of this legislation, the Alberta Citizen Initiative Act? Because it's a complex statute.
Yeah, Christine, well, thanks for having me, and I share your view. I'm a devoted patriot as well, and I want Alberta to be a part of Canada. But this is the situation that we're now in. The Alberta Citizens Initiative Act, adopted a few years ago, set up a framework so that people that wanted to put a referendum question to the public could do so. And there was the big part of this statute that was passed a few years ago was this constitutional pre-screen, which allowed a question to be stated to the chief electoral officer, or to a court rather, about the constitutionality of a referendum proposal. Is it even okay in the first place constitutionally to ask a question? That was the process that the Alberta Citizens Initiative Act set out at first. We're going to see that the government later changed course. They removed that pre-screening mechanism. And so we get the case that's been in the news via different means. But that's the whole idea here, is that this statute is supposed to channel and set up a means for direct democracy, a process for making sure that people's voice are heard on key questions that they might want to have a perspective on.
And look, I want to acknowledge that a lot of people in Alberta feel, unduly mistreated by Ottawa. It's a real sentiment, and I think there needs to be some sort of mechanism for a democratic response. Whether this is it or not, I don't know the answer to that. That's the mechanism that the provincial government has chosen. It's interesting because I'm very supportive of direct citizen engagement, and I'm kind of curious, if the court had not quashed this petition, what would the next step have been?
Yeah, well, one of the big things that we'll probably get into as we talk about this case is for the judge in the most recent case. Her view was that once the petition has been accepted, it starts a mandatory process where there must be a referendum.
Mhm.
There must be a question. And so this, I think for her, she viewed this as sort of the last stop for courts to say yes or no on a referendum. Because for her, once the process gets going, it doesn't stop until
Mhm.
there's a referendum, until the question is posed. So this is why this case is so significant, because it puts a bit of a damper on
Hmm.
the clear path that might have existed before to a referendum.
Hmm. We've got to go to break, but we will be right back. Welcome back to Canadian Justice, where we are discussing a recent case in Alberta where a court actually quashed a petition on Alberta separation. Now, this is interesting to a lot of Canadians because a lot of Canadians remember Quebec separation. I lived through that as a kid. I remember what it did to the country, and there was actually a really famous Supreme Court case on separation. It's called the secession reference, and I'm curious, Mark, what does the secession reference say about separation, and what role did it play in this decision from Alberta?
Yeah, it's sort of the big elephant in the room here. And so I would say the three things that came out of the secession reference that we really want to pay attention to here. The first bigger point, and this is important for this, democracy isn't the only principle of our constitution. In other words, we have a constitution, an entrenched constitution. And so that gives us a set of rules that when we vote and when we do certain things democratically, we have to follow these rules. So that's the first thing. We live in a kind of a complex democracy. It's not just a pure democracy. Second and third thing that the secession reference did was it cleared up some of the rules about what would happen when there was a referendum and it was successful. One of the first things that the secession reference says is that um, we can't have a unilateral separation because we're part of a federation. And so we want to have some process that's able to balance the needs of others in the federation. That's one thing. And yet another thing is that we need a clear question and a clear majority on that question. Once those things are kind of there, that is going to trigger a process of negotiation. But the court in the Quebec secession reference is very clear that we can't really spell out what that process of negotiation is going to look like. That's going to be a political process. That's going to involve the provinces working together, trying to come up with a solution. And so the court stops there in that case, but it sets out the framework that we're going to have to use to negotiate this upcoming referendum.
And how did that framework kind of apply in when the court considered the Alberta petition? Was that case considered?
Well, this case kind of plays a role in the process because again, once the court stipulates that there has to be a referendum because of the Alberta legislation, that means that is now again it's turned over to the political process, and that's the sort of thing that I think the Quebec secession reference was contemplating. It was
Okay.
contemplating that we're going to have the broad outlines of what we're supposed to do, and we have this extraordinary situation. But ultimately, it's going to be left up to politicians and the political branches to sort it out. And I think that's playing a role in the background of this case from Alberta.
Now, the main sort of a big part of the thrust of this Alberta case was because there was this First Nation that challenged the petition. And they said that there had not been consultation or consideration of how separation would affect Indigenous rights, which are protected under the Constitution, Section 35, as well as existing treaty rights. Alberta is under treaty, a number of different treaties. So maybe you could tell us about this First Nation that challenged the petition and what their position was.
Yeah, well, this is of course the part of the case that got a lot of attention, although it's not the dispositive part of the case. It's not the part that the case was actually decided on, but of course a big issue. We have a couple of Indigenous groups here that sought review in court of the Alberta Chief Electoral Officer's decision to approve the referendum petition. So they're saying we want to challenge that decision in court, and they do so on the grounds of their treaties. And the argument is basically this: Canada entered into treaties with the First Nations that are impacted here. And if separation is allowed to go forward, that essentially carves out the treaty relationship that exists between the Indigenous groups and Canada. In other words, we can't undo all of those treaties, this argument goes, just by allowing separation. And so they argue that because it's going to impact their treaty rights, they need to be consulted before the decision goes ahead to have a referendum. And this, of course, is the duty to consult, which is a constitutional rule that says before the Crown takes action that might affect Indigenous rights or interests, they have to consult with those groups. And so that was the core of the argument in the court on this case.
So that was part of the argument. There were other aspects of the case as well that, it was that were really what it was decided under, which is whether the decision to approve the petition was reasonable and if it complied with the statute. We have to go to commercial break, but when we come back, I want to ask you about those aspects of the case. Welcome back to Canadian Justice, where we're talking about our recent Alberta decision where a court quashed a petition on Alberta separation. And that petition had been challenged. There was a judicial review by a First Nation. And part of their challenge was they argued that the decision of the chief electoral officer to approve the petition was unreasonable. So, Mark, this is the real area that you study. This is kind of a big part of your focus, is the standard of reasonableness. So what does that term mean in a legal sense, and what did the court conclude about whether or not approving this petition was reasonable or not?
Yeah, this sounds to most people, this sounds like, angels dancing on the head of a pin. But this turns out it's really important. When we're talking about what standards of review are, what we're getting at is just how fussy a court should be when it reviews a decision of a government actor. So, how much space should we give that actor to make mistakes? You can imagine that in some cases where governments are asked to do complicated things, develop policies about some emerging area, we might give them more leeway. In situations where the government is, say, attacking a particular group or it's creating a rule that applies to a particular group, we might expect less leeway. So, what the standard of reasonableness tells us is that we're going to give some leeway to a decision maker, but it's going to be cabined, and we're going to make sure that the decision at least is intelligible. We can understand what it means, and that it takes into account relevant legal considerations that have to be taken into account in a case. And so here in this situation, judge finds the decision to approve the petition unreasonable and does so for basically two reasons that we can get into. But one of them was the duty to consult, and one of them pertained to the Citizens Initiative Act and what it required in this particular case.
Yeah, why don't you elaborate on that, both the statutory requirements and the consideration of the duty to consult?
Yeah. Well, first, on the statutory point, the big thing that we want to keep in mind here is that this case doesn't come out of nowhere. We have, as I mentioned earlier, we had a previous Citizens Initiative Act, and under that act, there was a question already put to the court about the constitutionality of the statute, and that was the Sylvester case, the Mitch Sylvester petition. Once that
This
legislation
was
was
also a Mitch
amended,
Sylvester petition as well, though, wasn't it? He's one of the separatist leaders, so I
yes,
think he's the one writing these petitions, my understanding.
yes, yes, that's right.
So
So we have
people
the
might
same
get a little
petition here
confused. So it's the same
because
petition,
you're right.
same
There's
question, same guy, different legal
yeah,
issues.
different legal issue. And so in that first case, the very first case, the court declared that they would that separate the referendum question as it was constituted was unconstitutional. And so when the Alberta government amended that first legislation, it said, okay, any referendum petitions that are kind of in the pipeline, we can bring them in again under our new legislation. The question that this case presented, the one that we have in front of us now, is was this Mitch the first petition in the pipeline still? If it's not in the pipeline, in other words, if the judicial decision saying it's unconstitutional killed it, then we can't revive it here. The CEO can't revive it in this case, the second case. And so the judge just simply concludes here that the CEO's interpretation of the statute, which it said allowed it to revive this petition, was wrong, was unreasonable. And so that was the real basis on which this decision was actually rendered. That was the error that the CEO made.
So
Here, when we go
yeah,
on to
go
the
ahead,
duty,
go
oh, go
ahead.
ahead. On the duty to consult part of it, that kind of came after the fact. And that came after the fact because the judge said, okay, well, if we have to proceed with a referendum, if the question is proper, then this is going to be the final time the government has to consult with Indigenous people. And so for her, as I said earlier, this was sort of the last stop on the bus. And we have to impose the duty to consult here, she says, or else there's no other opportunity to do it.
Yeah, I mean, there has been some criticism, though, of the approach that the court took here to what the duty to consult means. There's an op-ed in the National Post by Professor Dwight Newman where he argued that the court um, moved the duty to consult much earlier in the decision-making chain than previous cases have required. Um, and the consequence of that could be that governments might interpret this to mean that there's a duty to consult before allowing citizens to pursue all kinds of different political initiatives. And I think Dwight's criticism here is fair. We've got to go to break now, but when we come back, we're going to discuss that and other issues. Welcome back to Canadian Justice, where we're discussing a recent decision in Alberta where a court quashed a petition on Alberta separation. And part of the analysis related to the duty to consult with First Nations. And there has been some criticism that the duty to consult was moved much earlier in the decision making process, and that it's kind of a quite expansive interpretation of what that duty entails. So, Mark, do you agree with that criticism? I mean, what's the limiting principle here? If approving a citizen petition triggers the duty to consult because of the downstream possibility of effects on treaty rights, I mean, what kind of government decision wouldn't trigger the duty to consult?
Yeah. Yeah, I think Professor Newman's criticism in the National Post, there's a lot to it. Because the problem here is there are so many government processes that start off with some like discretionary decision, but then kick off a mandatory process. And you might think, okay, well, if we have to consult on all of these decisions, it's gonna bring government to a halt. The other, I think, thing here that is supporting Professor Newman's position is that when we're talking about all these duty to consult cases, these are all cases that involve natural resource development, impact on Indigenous rights. We're just dealing with a very different thing here with a referendum position. We're not dealing with an impact on a particular right per se. We're not dealing with an environmental issue. We're dealing with really the existential issue of Alberta's place in the country. And whether or not the duty to consult kind of fits into that world, that wasn't really something that the judge ended up discussing. So I do worry about the limiting principle here. I do understand that, as she said, this goes the other way. This is a gigantic decision. We might think about how we're going to end up consulting Indigenous people at some point here. That's a constitutional requirement. But just kind of taking the duty to consult and putting it in here in this very different world, I think that's what Professor Newman's worried about.
Hmm. I also think what a lot of people question is the balance between the court's role and democracy. So, with this petition, 300,000 people in Alberta signed it. So, how should courts balance this important democratic principle against constitutional constraints? Because to a lot of people, it seems like the courts are almost overriding democratic will. And look, you said that democracy isn't like a pure democracy. There's other principles in our constitution as well. But how do we make sure the balance is right, especially when courts are not elected?
Yeah. Well, I think there's two things here that make this a really make it a tough question for us in Canada. One is that we don't really have a constitutional history in this country of referendums. It's not the United States where direct democracy initiatives have sort of always been part of the picture. We're a parliamentary democracy, and so we're a representative democracy. We tend to think that the votes, the sorts of things that make up democracy, take place in legislatures rather than in votes, in referenda votes. So just that alone means that how this fits with our constitution is a little unclear. But the second point here is that again, democracy is not the only thing in our constitution. saying that is one thing, but how we make that a reality, that's another thing altogether. And the courts, when they are enforcing the Constitution under the Charter, they've got an extraordinary power. We have to be really careful that the decisions are well reasoned, that they're rooted in precedent, they don't make things up, because otherwise the legitimacy of constitutional review comes into question. We get this tension much more clearly then if the courts are just seen as making things up. So this is a tough balance, but the courts have to play their part in reasoning through their decisions. And I think in this case, one of the problems is the duty to consult holding isn't really well explained. And so we are left wondering, what does this mean for all sorts of government action? And most importantly, for this very important existential issue.
Hmm. So the government of Alberta has indicated they plan to, I believe, appeal this decision. Is that correct?
Yes. Yeah.
And in addition to announcing that, they have said that they are going to put a question about the question in a another referendum that they're having this fall. So I think we may not get clarity, but at least there will maybe be an answer about what Albertans want in the short term. Mark, thank you so much. We've heard today about the Alberta Court of King's Bench decision that quashed a petition seeking a referendum on Alberta independence. How should courts balance democratic participation against constitutional constraints? And when should governments be required to consult with Indigenous communities before political initiatives can proceed? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.